Another legal issue relating to performance of a contract should be discussed is hardship clause. In general, as a consequence of the general principle of the binding character of the contract, performance must be rendered as long as it is possible and regardless of the burden it may impose on the performing party. In other words, even in case that the performance of a contract becomes more onerous for one of the parties, that party is nevertheless bound to perform its obligation, except it is evident that the hardship conditions are satisfied. For more clarification, the clause under which contract modification or adjustment can be effected for unforeseen circumstances that alter substantially the equilibrium between the parties is called hardship clause. It can be recognized that hardship occurs where the occurrence of events fundamentally alter the equilibrium of the contract, either because the cost of a party's performance has increased or because the value of the performance a party receives has diminished. Under Article 420 of the Vietnamese Civil Code, circumstances shall be deemed to change substantially where the following requirements are met. First, there is a change to the circumstances due to objective reason occurring after the contract is entered into. The second, at the time when the contract is entered into, the parties are unable to foresee the change of circumstances. The third one, there is such a big change in circumstances that the contract could not have been entered into or could have been entered into with completely different contents if the party had foreseen such change. The fourth one, the continuation of performance of the contract without changing the contents of the contract will cause serious loss and damage to one party. And the last one, the party whose benefits are affected has taken unnecessary measures to the best of its ability and appropriate with the nature of the contract, but is unable to prevent or mitigate the level of affecting the benefit. So, it should be noted that hardship may not be invoked unless the change of the equilibrium of the contract is fundamental. Whether the change is fundamental or not will be considered on case-by-case basis. In fact, a substantial increase in the cost for one party of performing its obligation, or a substantial decrease in the value of the performance received by one party, including cases where the performance no longer has any value at all, or for the receiving party may act as a vital signal to recognize hardship. As we already seen, the substantial increase in the cost may be due to dramatic rise in the price of the raw material necessary for the production of the good, or the rendering of the services, or to the introduction of new safety regulations requiring far more expensive production procedure. By the same token, the substantial decrease in the value or the total loss of any value of the performance may be due either to drastic changes in the market condition. For example, the effect of a dramatic increase in inflation on a contractually agreed price. The inflation, or the frustration of the purpose for which the performance will require. For example, the effect of a prohibition to build on a premise acquired for building purposes. As mentioned, it should be emphasized that a change to the circumstances due to objective reason must occur after the contract is entered into. In other words, it is unforeseeable by the party at the time of the contract conclusion. And if the affected party had known of it, he would not have entered into the contract. Hence, if the disadvantaged party had known of the events causing hardship when entering into the contract, that party may not subsequently rely on hardship. It is also necessary to clarify that the circumstances cannot cause hardship if they could reasonably have been taken into account by the disadvantaged party at the time the contract was concluded. Moreover, the circumstance which occurred is beyond the control of the party to the extent that the affected party had used his best effort but is still unable to remedy the situation or even minimize the damage, and the continuance of performance of the contract will cause an extremely serious damage to one of the parties. In the same token, in some cases, it's unclear to distinguish between hardship and force majeure. Hence, there may be factual situations which can at the same time be considered as cases of hardship and cases of force majeure. If this is the case, the disadvantaged party is allowed to pursue either the hardship or the force majeure. If such party relies on force majeure, it's more likely that the party intends to be released from its performance of a contract. On the other hand, if a party invokes hardship, it may have the purpose of renegotiating the terms of the contract so as to allow the contract to be kept alive under the term of the contract may be modified. It seems that the concept of hardship in Article 420 of the Vietnamese Civil Code almost mirrors that in the principle of international commercial contract, PICC, which brings Vietnamese contract law closer to modern contract law, and also enable the court to deal with the supervening event as being considered as an exception to the principle of pacta sunt servanda. In order to apply the hardship clause, severe conditions are strictly required. It may cause the fact that it is almost impossible for the contracting party to rely on hardship during the course of performing the contract, even though the party may find it appropriate to adapt such requirement. Where circumstances change substantially, the party whose benefits are affected has the right to request the other party to renegotiate the contract within a reasonable period of time. So, where the parties are unable to reach agreement on amendment of the contract within a reasonable period of time, so either party may request a cost at the last resort to terminate the contract at a definite time or amend the contract to balance legitimate rights and benefits of the party due to substantial change in circumstances. It should be noted that the court is only permitted to make a decision on amendment of the contract in a case where termination of the contract will cause loss and damage of an amount higher than the cost for performance of the contract if the contract is amended. Now, we will take time to go in further detail on the effect of hardship. In case of hardship, the disadvantaged party is entitled to request renegotiation for the purpose of modification of the contract to adapt to the changed circumstances. For example, A. Enter into a sale contract to supply material for B's manufacture. Such material has to be imported from abroad, namely from country C, but due to an unexpected ban on such importation from country C, there is a shortage of such material on the market, and there is an evidence that it's also extremely difficult for A to import such goods from another countries and substitute. As a result, the cost of material increased dramatically. A is entitled to request B to renegotiate the original contract price so as to adapt it to the changed circumstances. A request for renegotiation is not admissible where the contract itself already incorporates a clause provided for the automatic adaptation of the contract. For example, a clause providing for automatic indexation of the price is certainly then the case. Another point is that the request for renegotiation must be made within a reasonable period of time. It should be better for the disadvantaged party to request for renegotiation without a new delay. It should be understood that the request for renegotiation must be made as quickly as possible after the time at which hardship is allowed to have occurred. Although the divested party does not lose its right to request renegotiation simply because it failed to act without a new delay. Such delay in making the request may adversely affect the finding as to whether hardship actually existed and if so, its consequences for the contract. Upon failure to reach agreement within a reasonable time, either party may resort to the court. Such a situation may arise either because the non-disadvantaged party completely ignored the request for renegotiation, or because the renegotiation, although conducted by both parties in good faith, but did not have a positive outcome. If the court finds hardship, it may react in a number of different ways. Namely, it may, if reasonable, terminate the contract at a date and on terms to be fixed, or adapt the contract with a view to restoring its equilibrium. However, the court is only permitted to make a decision on amendment of the contract in a case where termination of the contract will cause loss and damage of an amount greater than the cost for performance of the contract if the contract is amended. As noted, during the process of renegotiation of amendment or termination of the contract and during the period the court resolved the case, the party must continue to perform their obligation under the contract unless otherwise agreed. It means that the request for renegotiation or the request for the court to deal with hardship does not entitle the disadvantaged party to withhold performance of the contract. During renegotiation between the party or settlement by the court, because the party must continue to perform the contract in accordance with the agreement, it seems to lessen the disadvantaged party incentive to request for renegotiation. Finally, whether the disadvantaged party finds it difficult to rely on hardship or not, the hardship clause still opens the door for the contracting party to deal with unforeseen difficulty in the course of performance of the contract.